I have issues which makes me a little bit uneasy with this circumstantial recent possession. Number one, it was a prosecution case that, having established that the house number 226 is jointly owned by the accused and one Mary Deya, and from whence the subject children were recovered, and constructively the accused was in possession. Additionally, the prosecution held that on the basis of the evidence of BW19, Emmanuel Grammar Simiyu, producing XP number 54, being the accused travel history with the 6 entries tabulated as 20th of April 2004, 26th April 2004, 27th April 2004, 5th July 2004, and 8th of July 2004, while he was departing from Jomo Kenyatta International Airport, all go to indicate that the accused must have known that the children were in his house. The defense on the other side position was that on recoveries, the accused was in the UK. At the time the subject were recovered from the house. On travel history of the accused, the dates do not fall or tally with the dates that the offenses were allegedly committed by the accused. And in any event, Section 12 of the Parts and Registration Act says that no person shall be entered in the register as the father of any child, except either at the joint request of the father and mother, or upon the production to the registrar of such evidence as he may require that the father and mother were married according to law or in accordance with some recognized custom. The position of the court in this respect is this. House number 226 Mountain View Estate is jointly owned by the accused and Mary Deya. But at the time the children were recovered from the ring, Mary was arrested and charged with the offense of stealing of children, and she was acquitted. At the time, the accused was in the UK. However, the prosecution case is that the accused, being a co-lessee of the house, was constructively in possession of the subject children. Now, having denied knowledge that the subject children were in the house number 226, that he never knew the children were in the house number 226, it behoved on the prosecution to prove that the accused had knowledge that Mary Deya, Rose Kiserem, and Miriam Nyeki were arrested from the house had the subject children in his house. Number two, the fact that the accused traveled frequently into the country does not necessarily infer that he had come to steal the subject children or abet crime, so that even if he went to his house upon coming in the country, that is not the basis to infer that he knew the children were in the house. The reason is, take the first scenario for example. Suppose he met them or he did not meet them. How can knowledge be proved indirectly? The second scenario, suppose Mary Deya had joined a certain cult without the knowledge of the accused person, and assuming that the accused was getting in the country with her knowledge, could she still retain the children in the house? Traveling into country per se and going into the house or not is not a substitute of linking knowledge on the part of the accused to the subject. Number three, the state relied on the registration of birth and birth certificates to hold a view that indirectly the accused knew the existence of the children. PW number 3 produced XP number 5, and for Elijah P. Juma, entry number 9, which indicate whether Mary was married, the father is not indicated. However, the mother is indicated as Mary Deya. The capacity form, it is marked as parent. For Miriam Adongo, the name of the father is indicated, but on whether Mary is married, the father is not indicated. Know so that in respect to the two children, they were allegedly born on the same day, 20th May 2002, and it's not possible that the name of the father can appear for one and not the other, and yet they were born on the same day and the same time. Finally, the accused was charged on the suspicion committing the offense by the fact that Mary Deya had been charged and convicted in the High Court criminal case number 97 of 2011, and on the assumption that circumstantial evidence could suffice, given that there was a lease from where the accused from where the subject children were recovered, was co-joined with Mary Juma and the accused person. In the end, it is true the prosecution made a lot of capital out of a number of circumstances in a bid to establish the accused was guilty. But that evidence does not satisfy the legal requirements of circumstantial evidence to warrant the conviction of the accused, and ultimately make a finding that the prosecution has not proved their case in all the counts beyond reasonable doubt, and acquit the accused person in all the counts under Section 215 of the CPC, and set him free unless otherwise held back